Hi, and welcome to Scholars Hub at Home. I'm Julie Lafford, the Executive Director for Alumni Engagement at York University. Thank you for joining us for today's lecture, Intimate Partner Violence and Access to Justice, with Professor Janet Mosher from Osgoode Hall Law School. We've chosen this topic for today's lecture because tomorrow, November 25th, is the UN International Day for the Elimination of Violence Against Women. I'll begin with our land acknowledgement. Since we're not all gathered in the same space, I recognize that I might not be acknowledging the territory you're currently on. And if that's the case, please take the responsibility to acknowledge the territory you're on and the current treaty holders. The website native-land.ca is a good resource for this. As a member of the York University community, I recognize that many Indigenous nations have long-standing relationships with the territories upon which York University campuses are located that precede the establishment of the university. York University acknowledges its presence on the traditional territory of many Indigenous nations. The area known as Takaranto has been caretaken by the Anishinaabeg Nation, the Haudenosaunee Confederacy, and the Huron-Wendat. It's now home to many First Nation, Inuit, and Métis communities. We acknowledge the current treaty holders, the Mississaugas of the Credit First Nation. This territory is subject to the Dish with One Spoon Wampum Belt Covenant, an agreement to peaceably share and care for the Great Lakes region. I'm truly grateful all that I've learned and continue to learn from Indigenous peoples, both on your campuses and beyond. Before I introduce our speaker today, I'd like to tell you some exciting news. In the Maclean's 2022 University Rankings, which was published last month, York received an impressive 6th place ranking against all other comprehensive universities in Canada for the second year in a row. York's rankings also increased in some key priority areas, including the national reputation category and the student satisfaction section. This is really great news and something we can all be very proud of. You can read more about York's recent placement and additional York news and happenings on our website, yfile.news.yorku.ca. Now, as usual, I'd like to conduct a quick poll before this lecture. Today's question is, how would you rate your knowledge regarding the topic of today's presentation? So that poll should have popped up on your screen, and please take a moment to respond to that. If you do need help with the Zoom webinar at any time, feel free to click on the Q&A button at the bottom of your screen and enter your question. Our team is ready to help you. That same button can be used to submit questions for our guest speakers to answer during the Q&A. Please note that all your questions and comments are visible to panelists and staff working behind the scenes, so we ask that you keep your comments relevant and respectful. So now I'm pleased to introduce the speaker for today's lecture, Janet Mosher, who's the Associate Professor at Osgoode Hall Law School. Janet is a co-founder and current co-director of the Feminist Advocacy Ending Violence Against Women clinical program, which runs in partnership with the Barbara Schleifer Commemorative Clinic. The clinic offers legal, counseling, and interpretation services to marginalized and racialized populations of women who've survived violence. Janet's research focuses on law and gender-based violence, access to justice for marginalized populations, welfare policy related to the intersections of poverty and violence against women, women's homelessness, and legal aid. Welcome, Professor Mosher. I'm so glad you could join us today. You can go ahead and share your screen, and I'll be back after your presentation for the Q&A. And turn the camera on. There she is.
Yes, thank you very much for that introduction, Julie, and thank you to all the participants for joining us today. Just give me one moment here, and I'm going to share my screen with some slides. Yes, so there we go. Intimate partner violence is widely recognized as a pervasive form of gender-based violence, a human rights violation, and we know it's a leading cause of women's morbidity and mortality. In 2014, United Nations Women described violence against women and girls as a pandemic, given its global pervasiveness and the depth of harm caused. You will know that during the current COVID-19 pandemic, reports of increases in the rates and the severity of intimate partner violence have increased, with particularly acute impacts for Indigenous women, non-status women, women with disabilities, and low-income women. And these reports of the increases in the rates and severity of intimate partner violence have been reported by countries across the globe, including Canada. And in this context, gender-based violence has frequently been referred to as a shadow pandemic. As already mentioned, tomorrow is the International Day for the Elimination of Violence Against Women. The United Nations has called on countries to ensure that essential services are available to survivors, to focus on prevention and the collection of data, and to prioritize addressing violence against women in COVID response and recovery efforts. In an earlier call for country reports during COVID, UN Women specifically asked countries to report on whether courts remained open and accessible to women fleeing gender-based violence. The research that I'll share with you today is focused in part on the accessibility of courts, although primarily in a period before COVID, but more broadly seeks to explore and document the access to justice barriers encountered by survivors of intimate partner violence, particularly when there are likely to be intersecting legal issues. To provide a better sense of what I mean by this, let me provide a brief hypothetical. Imagine a situation where a neighbor, out of concern for the safety of a woman and her children, contacts the police. The police arrive, interview the parties, and arrest her male partner. Let's further assume that the couple has 2 young children. The police will contact a Children's Aid Society to investigate and determine whether the children are in need of protection. Assume that several months later, the mother initiates a family law proceeding seeking sole custody of the children, now in Ontario referred to as decision-making responsibility, with supervised access or parenting time for the father. How might the criminal justice and child welfare system interventions impact the outcome in family law? What if the father is convicted or acquitted? Or what if in the criminal trial, the mother denies the violence? Or what if she minimizes the violence? What if the violence is or is not verified by child welfare authorities? These are the sorts of questions that animate the project that I'm about to describe. So the research is funded by the Social Sciences and Humanities Research Council and a related project by the Law Foundation of Ontario. You'll see the project involves 5 academics from 4 institutions and 3 phases. We've completed all of the first phase, much of the second phase, and the third phase is in its early stages. So I'll speak primarily to the first and second stages. In this first stage, we've mapped all of the statutes, regulations, and policies that touch on intimate partner violence, domestic violence, family violence. There are a range of different terms used. And we've done this for all Canadian jurisdictions, so federal, provincial, and territorial. And this mapping revealed a wide variety of statutes and regulations touching on intimate partner violence across multiple fields of law, and among them criminal, immigration, victims' compensation, residential tenancies, social assistance, and employment standards. And that's not an exhaustive list. And we've since turned that research into an accessible ebook where each of these areas of law is summarized as they pertain to intimate partner violence for every Canadian jurisdiction. On the positive side, what the mapping revealed is a growing recognition of the relevance of intimate partner violence to these various domains of law. But it also revealed considerable variation between jurisdictions, as well as variation across legislative domains within any given jurisdiction. And we've highlighted some of these in a chapter in a recent book called The Justice Crisis. And a somewhat expanded version of that is available on SSRN, and the link is there on the slide. This next slide shows table 1 from that chapter. And this provides a snapshot overview of all of the Canadian jurisdictions. And you can see some of the differences in terms of whether or not intimate partner violence or domestic violence is explicitly recognized within a particular area of law. I note that this is current to March 31st, 2020, and there have been some important changes since. So just to draw one difference, as an example, we can see that civil protection order legislation exists in all provinces except Ontario and Quebec. And I would note here that Quebec has provisions for civil protection orders, but they're not specific to domestic violence, where in the other jurisdictions, they are specific to domestic violence. So this gives a very broad brush overview, but when we drill down further, we see significant differences between provinces, even where there's been a legislative response. So we undertook this deeper comparative work last summer for a project is underway to develop a federal national action plan on violence against women and gender-based violence. And this initiative was led by Women's Shelters Canada. And I've included here links for both the executive summary and the full report, and our background paper is included in the full report. And in doing this work, the differences that we saw between and sometimes within jurisdictions fall into what I've described here as 4 categories of differentiation, or understood differently, 4 domains of inequality. And I'll review these quickly. One area of differentiation is with respect to the definitions provided of domestic violence or intimate partner violence, whatever the term might be. And a significant area of difference in terms of those definitions is whether the definition includes something in addition to other than physical violence. So for example, whether psychological violence is included, or whether coercive control is included. And by coercive control, I'm referring to the use of isolation, surveillance, threats, put downs, microregulation of daily activities to entrap, control, and instill fear. And there's mounting evidence that these elements of coercive control are much more predictive of serious, including lethal violence. So it matters if the definition of domestic violence includes or doesn't include coercive control. And we can see significant differences in, for example, civil protection order legislation and whether coercive control is included. In fact, only 3 jurisdictions include coercive control. Another area of differentiation is with respect to the status, and here referring to marital status or immigration status that's required to access an entitlement or potential support. So for example, if you're in a dating relationship, whether or not you are able to access a civil protection order will depend on which province or territory you live in. In some, you will be able to access a civil protection order, and others you will not be able to do so. A third area relates to the verification or proof of intimate partner violence that's required to access a legislated entitlement. You'll see variation between jurisdictions, but also within jurisdictions. And these can range, for example, from a form on which you simply need to tick a box if you've experienced intimate partner violence, to a requirement that you provide verification or substantiation from one of a list of named professionals, such as doctors, police officers, lawyers, social workers. And that raises significant concerns in relation to which women have access to those kinds of named professionals that are necessary to verify or substantiate the abuse. And the fourth category noted here relates to the supports and resources that are statutorily created for survivors. And these vary widely across jurisdictions. And just to give one example related to victim compensation, the amount of compensation to which a survivor may be entitled ranges from approximately $2,000 in some provinces to $100,000 in other provinces. So really significant differences. And also there are differences in what might be compensable. So for example, Saskatchewan is the only province where one head of funding is for counseling for a child who has witnessed domestic violence. So in sum, what this reveals is that access to remedies, resources, and supports, which are vital to safety and to healing, is terribly uneven. And much depends on where a survivor lives, her marital status, her immigration status, and whether her networks include supportive professionals who are knowledgeable about intimate partner violence. Now, while a review of the statutes and regulations tells us about the law on the books, it doesn't reveal what happens on the ground. And we know that there is often a disjuncture between the two, that is, between what a statute might tell us and the rights or entitlements that people actually have access to on the ground. So this is why the case law review and the interviews are important components of the project. And that takes me to phase 2 of the project. And in this phase, we've been looking at various domains of case law, and I'm going to focus on the research we've been doing on the family law case law. And we began here by looking at decisions in Alberta, Saskatchewan, and Ontario in the period 2010 to 2017, and we've since been updating that. In Saskatchewan, in that period of time, there were 150 relevant cases, family law decisions with domestic violence. There were hundreds and hundreds in Ontario. So what we did in both Ontario and Alberta is randomly select cases so that we ended up with a similar size sample as Saskatchewan, so roughly 150 cases. And we included those as well as all appellate level decisions. And you'll see here that the number count, when we further narrowed it to family law decisions where there's domestic violence, there are parenting issues raised, and the decision made some reference to the engagement or involvement of another area of law, that we end up with 29 cases in Alberta, 43 in Saskatchewan, and substantially more in Ontario, 71 cases. And the higher number of cases in Ontario is largely explained by the regular involvement of the child welfare system. And you'll see here on this slide, the family law decisions with child protection involvement, that in Ontario, it's about 82% of cases that we looked at where there was something in the decision that told us that the child welfare system had been involved. Importantly, in Ontario, it's not just that there are significant numbers of cases where there is child protection or child welfare system involvement, but also the role that the child welfare system plays is really significant in many of the Ontario cases. And that's both the whether or not the child welfare system has verified the abuse or not, and also the recommendations that child welfare authorities may have made regarding the parenting outcomes. Now, just before I turn to some of the intersections between family and criminal law, a very quick look at self-representation. You'll see, again, the numbers are highest in Ontario. We have a really significant percentage of litigants that are appearing unrepresented in family court matters. So almost 60% in Ontario where either the mother or father is unrepresented. And that has some significant implications for access to justice. Turning now to the intersections between the family law cases and criminal law. This slide shows the number of cases where there were criminal charges. And again, number is highest in Ontario. You'll also see there are some instances of mutual charges and also cases where mothers have been charged. And there were additionally cases where there had been police involvement, but no charges laid. And this was highest in Saskatchewan. So this leads us really to the question of whether the criminal justice involvement for intimate partner violence makes a difference to family law outcomes. The short answer, not surprisingly, is yes, it often does, but not necessarily in the way that one might predict. And I'm going to speak briefly to 3 forms of interaction that we've observed. And I have the 3 listed here, and I'll take up each one in turn. So in a number of instances, although allegations of violence and even a criminal charge or conviction are conveyed in the background of the case, they are often not then picked up in a discussion of the factors relevant to parenting, or if they are, they're given very little weight. So while a criminal charge may establish factually that an assault, for example, has occurred, it may nonetheless have little impact on the outcome. In a very recently published article, Morton et al. Reviewing a case sample in Ontario for the 2019 and 20 period comes to a very similar conclusion. And in the criminal context, bail, probation, peace bond conditions often include what's called a no contact order, prohibiting the accused from contacting the victim. And these and other orders, such as a requirement that an accused participate in a program such as PARS, which is the Partner Assault Response Program, these types of orders can affect family law parenting decisions, both directly and indirectly. So an example of a direct impact would be where, for example, a family law court concluded in one case that an order could not be made for joint custody because of the existing criminal law order prohibiting contact. And family court judges expressed frustration about this from time to time, noting that the criminal justice system is not designed to interrogate and determine the best interests of a child, nor to determine interests in the family home. Yet the criminal no contact order bars one parent from the family home and can significantly limit the removed parent's interactions with the children. The sorts of indirect effects that we see is where an accused person fails to comply with a criminal court order, a family court judge may take that as some evidence that this is a person not likely to comply with a family court order. In the case of orders to participate in counseling of some kind or a PARS program, again, the failure to complete that programming will be regarded negatively in terms of thinking about custody and access. But importantly, if the accused has completed such a program, that's regarded very favorably in the decisions about parenting. And I just flag that raises some concerns because of the research that shows the limited efficacy of such programs in actually ending abusive behavior. So the second kind of interaction that we see is the impact that the involvement in the criminal justice system might have in assessing the veracity of the allegations of domestic violence that are raised in the family law proceeding. So statements that might be given in the criminal context, either at trial or to the police, that are purportedly inconsistent with those given in the family law proceeding are relied upon to undermine women's credibility, to find that she's not credible in the family law proceeding. Family law judges will consider whether police were called when assessing the veracity of domestic violence allegations. That women have not disclosed to the police or disclosed only after separation is often relied upon to discount or dismiss their allegations of domestic violence. And certainly there are a number of cases that raise serious questions about whether the presiding judge had an understanding of the multitude of reasons why women don't call the police. Several judges seem to assume that if the allegations were true, women would have immediately gone to the police, although statistically, only 22% of women do. Similarly, in many cases, judges fail to grasp why women might have recanted the allegations in the criminal proceeding, minimized the severity of the violence, or had sought to have a no contact order altered. Importantly, there are cases, though, decided by other judges who recognize that fear of retaliation or escalation of the violence, shame, and the fear that their children will be removed from their care are among the many reasons that women do not report to the police. Now, while not reporting to the police is often a reason to doubt the veracity of allegations, at the same time, going to the police in some instances also raises suspicion. And that is a suspicion that the allegation is part of a manipulative ploy to secure custody. This is made strikingly explicit in one particular case where the judge says, and I'll quote briefly here, "It is an important fact that Ms. L did not set up the incident of January 6th with a pre-planned scheme to take the children away from Mr. D. She did not call the police and indeed had not done so in the past, except on one occasion when he had threatened suicide. She did not know in advance that he would be arrested as a result of this incident or what the consequences would be." And these are all things that the judge relies upon in coming to the conclusion that her allegations of domestic violence are credible. In other words, she's not a woman who has set up an incident with a pre-planned scheme to take children away. And that ties into the third interaction, which is criminal justice involvement may and does, in a surprising number of cases, raise the specter of strategic engagement for the purposes of manipulating the family law outcome. So a common response of the alleged perpetrator, sometimes even in the face of a criminal conviction, is to say that the allegations of domestic violence have been fabricated as part of this manipulative ploy to secure custody. And often accompanying this is a further assertion that the mother is in fact the perpetrator and the father is the victim. And increasingly common is a further claim that the mother is alienating the children from the father. This emerges as a very consistent theme in the family law cases and also arises in the criminal law cases as part of the defense to charges of domestic violence. And I've included here on the slide a quote from one case signaling about how easy it is to readily invoke the criminal justice system as a tool to hijack the family law proceedings. In other cases, courts have said these allegations must therefore be very carefully scrutinized by the court. So one final observation that I'll speak briefly to is what I termed here legal system abuse. And what I mean to capture here are the range of behaviors deployed by perpetrators to use the legal system instrumentally to further their power and control. This can take the form of drawing out family law litigation over many years, and perpetrators will sometimes explicitly threaten women that they will ruin them financially and ensure that they cannot live without them, or they're threatened to ensure that women will never see their children again. So he will bring multiple and repeated legal proceedings. If she is represented by a lawyer, he may report her lawyer to the law society alleging some form of misconduct in order to deprive her of legal counsel. There's a range of tactics one can see in these cases. Some academics have referred to this as procedural stalking, and it's only in extreme cases that courts name this as an abuse of the court's process and limit the perpetrator's ability to initiate new legal proceedings. Also, what became very evident in these cases is that perpetrators will falsely report women to any number of legal actors who are then mandated to investigate. So in these cases, we saw repeated reports to child welfare agencies, to social assistance and social housing providers, to Canada Revenue Agency. The list goes on and on. And the upshot of making these reports is that women will be investigated. Often during the period of investigation, they will be cut off benefits. And in extreme circumstances for a woman without permanent residence status, it may result in the removal from Canada. What's largely absent in the judicial decisions is an understanding of this kind of conduct as part of a pattern of coercive control. And the relative silence around or invisibility of this pattern of conduct, this particular kind of manipulation of the legal system, stands in marked contrast to the loud and persistent appearance in these cases of the narrative framing mothers as manipulating legal systems to alienate fathers. So a few quick concluding remarks about access to justice. So it's not only about getting through the courthouse doors, and indeed being regularly pulled through those doors is often experienced by survivors as a denial of access to justice. Moreover, we need to look behind the courthouse doors. Do women have access to legal representation? Is abusive litigation being addressed? Do actors within the legal system have the necessary in-depth understanding of the dynamics of intimate partner violence? And do they recognize ongoing power imbalances? And is there attention to system interactions and whether those are making women and children safer or they're enlarging the harm? And beyond the courthouse doors, I'm back to some of my earlier remarks of paying attention to the differences, the inequalities, the inequities that exist across the country in terms of the supports and resources to which women have access for safety and healing. So I'll end it there and I will stop sharing my screen, and then I think we're ready for questions.
Yes, indeed. Thank you, Janet, so much. A very sobering lecture, but also really important and really, really interesting. I love your approach to the data. So as you said, we do have time now for questions from the audience. So audience, please use the Q&A function at the bottom of your screen to ask questions. For those of you watching on Facebook, you're welcome to submit questions or comments through Facebook directly, and the team will send them over to me. So I'm going to kick things off with a question. First, Janet, can you tell us a little bit about how your research builds on or departs from other conceptualizations of access to justice?
Yeah, thanks very much, Julie. There is a great deal of research on access to justice and a wide acknowledgement that there is what's often been described as an access to justice crisis in Canada. A lot of the work, especially the earlier work on access to justice, was really done primarily by lawyers and legal professionals and from their perspective. And a lot of it really has focused on getting into the court, getting access to an authoritative decision maker, where the primary impediments, and there are important impediments, have been identified as costs of litigation and the time involved. I think not only our research, but some other research more recently has started to focus on access to justice from the perspective of those who are experiencing injustices, and kind of grounding access to justice from the lived experiences of different communities of people. So for our work, trying to think about what does access to justice mean or look like for survivors of intimate partner violence. And in that context, I would say, access to justice is not possible for survivors unless actors, lawyers, judges, probation officers, all of those actors within the legal system really have an in-depth understanding of domestic violence, so that knowledge is really important. There's a critique of a lot of access to justice literature that especially we as lawyers conflate access and justice. Think if you get into the court, you've got justice. Say, well, actually, that's not the case. So again, the knowledge of lawyers and decision makers about domestic violence is super important, but also outside of the courtroom, looking at that variability in statutes and regulations, all of that is really important to substantive justice. And the last thing maybe I would just add here is, I think in most conceptions of access to justice, safety doesn't appear. And I think for survivors of intimate partner violence, thinking about safety as an integral component of access to justice is absolutely necessary. We know for many survivors of different forms of gender-based violence, the legal process itself is often experienced as very harmful, as trauma-inducing, and it undermines women's well-being. We also kind of have a really good sense that again, women's safety can be compromised by litigation, and so putting safety into the equation of access to justice, I think something that really comes very clearly from the research that we've done.
That's really interesting. So, I mean, I was quite shocked earlier. You said that 60% of Ontario litigants are unrepresented in family law cases. Have I got that right? Yet you're also suggesting that the financial barriers are maybe just one of many barriers to access to justice. So
yes. So the problem of the lack of representation is one that's been identified for many different areas of law. I mean, it's a problem in criminal law. It's a problem across many areas of law. The rates of unrepresentation, or some say self-representation, we can talk about which term is the best one to use. They're especially high in family law. So, our sample was specifically looking at cases where there was domestic violence. I think in almost any incident, it's really difficult to represent oneself. I think it's particularly difficult if you are a survivor of gender-based violence. There are some really horrid examples in these cases where abusers are self-representing. And then they get to cross-examine their former intimate partner. And, I think in the worst examples, it's, perpetrators who've chosen to self-represent for many reasons, but including because it gives them an opportunity to really further their power and control. And I remember vividly in one case, the judge just describing how intimidated the mother was while she's, in the witness stand and being cross-examined by her former partner. We know too that the power imbalance that existed during the relationship suddenly hasn't disappeared at the time of separation. Separation is the time when violence often increases. It's the most dangerous time for women. So again, recognizing that context of the inequalities of power makes it, I think, particularly difficult for survivors to represent themselves. I haven't gone into the details around the availability of of legal aid. Again, that's one of the areas that looks quite different across the country. It can change quite dramatically over time, but certainly some provinces prioritize funding for legal aid certificates in circumstances where domestic violence is an issue in a family law context. But that doesn't exist everywhere. And moreover, the income thresholds to qualify for legal aid are very, very low. So there will be lots of women where there's serious domestic violence, but they do not qualify for a legal aid certificate. And as you will know, the costs of lawyers are, it's incredibly expensive, and family law proceedings can be very long and very complex.
Thank you for elaborating on that. It sounds like a really, really complex subject, and I know you're just trying to get the highlights across today. I do have an audience question for you. So Stanley asks, is it possible for you to give an indication of the extent of domestic violence either in Ontario or nationally over the last, say, 10 years, including before COVID? And is it on increase, decrease, or the same over time?
Right. So I guess a couple of things that I would say. There are various ways in which the data is gathered, and using different definitions of domestic violence. So sometimes all that's captured are criminal code offenses. So assaults, for example, it doesn't capture other kinds of coercive controlling violence. So that's important. And when we look at police data, it shows that the numbers have stayed relatively constant over the last decade or so. So not a lot of change. We also know that many survivors do not ever report to the police. There's another method of trying to ascertain the extent of violence, and it's through a large-scale national surveys conducted by Statistics Canada. And those surveys, and we're just waiting for actually the reporting out on the most recent survey that was done. They are self-reports from this randomized sample, and they show that the numbers have dropped a little bit and then gone back up, but not significant amounts of change. I think during COVID, the sampling has been much more local. So as far as I know, no national sampling of a large population group, but clearly from the local samples, really significant increases in intimate partner violence. And around the globe, a lot of research showing significant spikes. And I think the other thing to note about that is research that's connected to past forms of significant public health events or emergencies. So there's quite a bit of research, like post-Hurricane Katrina in the US, is that the rates of domestic violence go up, and they stay up for a considerable period of time because there's lots of correlates between the stressors of a pandemic and domestic violence that mean that the lasting impact of the pandemic will also have a lasting impact on the rates of domestic violence.
Thank you for that. I have another question from the audience, from Kelly. Given the risks and costs to all parties of the court proceedings, would it be better to establish a tribunal to hear cases solely involving intimate partner violence? Virtual oral hearings could reduce the safety risks. Administrative tribunals are cheaper, and their decisions are often legally binding. What are your thoughts?
Right, so that's a big question, and there'll be lots of different thoughts about this. And I do recall we had a student at Osgoode a few years ago who was looking at just this question about whether a tribunal might be the better route. So one thing that I would say just related to that is certainly the possibility of a dedicated court where you have the expertise is, I think, an important consideration. So in the criminal context, we've developed what are called specialized domestic violence courts, and they exist throughout Ontario. But what they actually mean or look like varies from one court location to another throughout the province. But at a minimum is to include a specialized team of prosecutors and judges with specialized training. And I think that can really make an important difference. We also have in Toronto an integrated domestic violence court that hears a small number of cases that are involved in both criminal and family law. And again, there are just 2 judges that sit in that court. It sits every other Friday. Those judges have considerable expertise, and they're also able to deal with some of the complicated intersections between family and criminal, and to ensure that there aren't inconsistent orders given, to ensure that the best interests of the child are prioritized, et cetera. So looking at other kind of models is really important. Whether a tribunal structure is just the right structure, I'm not sure, but I certainly think imagining the development of players with expertise is really important. As for online proceedings, we've all, I think, learned a huge amount over this past 18 months about the potential for online proceedings. And I think in the justice sector, there is an assumption that there will be a new kind of normal, and it will include online proceedings in many, many different areas. I think online proceedings have both great potential around enhancing access to justice and some real limitations and concerns as well. And so, it's probably a time for reflection and looking at what do we learn from the past 18 months that can really help us do a good job of thinking this forward into the future, and what might be the best kind of blending of online and in-person modes of dispute resolution. And maybe just to this, I will add, as some of you listening may know, we've had really significant reforms in family law at the federal level through changes to the Divorce Act, which were proclaimed for March 2021. And a few other provinces have followed suit, and Ontario is one of them. And the new legislative frameworks really embrace what's often referred to as alternative dispute resolution. I should say, importantly as well, this new legislation federally and in Ontario includes a much more expansive definition of family violence. It builds coercive control in. It makes this a required factor for judges to consider in determining parenting. So all of that's really, really important. But on the alternative dispute resolution side, the legislation encourages parties to attempt to resolve matters without going to court. So through mediation or other alternatives to adjudication. And again, there's lots of positive things that can happen through non-adjudicative processes, but there's a real concern about women feeling pressured to participate in those processes where they are survivors of intimate partner violence. And again, I don't want to be a person who says that's never possible to have a really good process, because surely litigation is not often a good process for women. So alternatives might be workable, but you really need to have, again, personnel who are extremely knowledgeable, and especially about the power imbalances, and those processes need to be really well funded and supported. So although they're often marketed as being less expensive and faster, I think sometimes they are not, if one is to do them really well and have them resourced in the way that they need to be to ensure safety and fair outcomes.
Thank you so much for that. I'm afraid that is all the time we have for Q&A today. I know there's some we didn't get to. I apologize to those of you who took the time to ask questions and we don't have time for. So Janet, thank you once again for spending your time with us and for bringing this really important and timely lecture to us today.
Thank you. My pleasure.
All right. So you're welcome to turn off your video at this point. For those of you who'd like to share today's session with family and friends, it'll be posted to our YouTube page, youtube.com/YorkU alumni. And you can also watch past lectures on that page as well. I do have a poll before you go. Please tell us how you would rate your knowledge of today's topic following this discussion. And that question should appear on your screen now. As we close out 2021, we do have a full calendar of events lined up for you over the next few weeks. Our next Scholars Hub lecture is December 8th in partnership with Glendon College. It is Video Gaming for Good, Play in the Pandemic, featuring Allison Harvey. And on Saturday, November 22nd, our York Circle lecture series will feature a panel presentation titled Francophone in Canada, Negotiating Minority and Majority Rights. Both of these events will be available in both French and English. You can learn more about our events on our website, yorku.ca/alumni and friends. But before you go, I have a special request for all of you. The alumni engagement team is planning for the new year, and we'd love to hear your input on topics that you're interested in hearing through the Scholars Hub lecture series. So the team's going to share a link in the chat now. Please take a couple of minutes to share your ideas and your feedback. We would really appreciate it. Your suggestions and feedback on any of our programs or offerings are always welcome through any of our social media channels or email alumni@yorku.ca. Thank you for spending your lunch hour with us. Stay safe.